Executive Director of Citizens Union. I'm joined here by my colleague, Rachel Foss. Citizens Union, as it relates to ethics reform, ideally supports the creation of a unitary body charged with overseeing ethics in the executive and legislative branches, with no one entity or individual elected official making a majority of the appointments. Lobbying and campaign finance enforcement should be also housed with that entity, ideally. We believe that this Uber entity would be best able to monitor the nexus between money, ethics, campaigns, and lobbying in state government. However, we have supported, in the interest of achieving reform in incremental steps, separate oversight bodies as present in the ethics legislation last year, as sufficient independence was provided for each body. For any ethics entities, we support the following. One, enhanced restrictions should be placed on members that are part of a commission or commissions overseeing ethics, lobbying, campaign finance, reporting and enforcement, and lobbying, reporting, and enforcement. A commission should not include members who are current legislators, serve as party officials or are seeking a party leadership position, hold public office, have a paid position with the campaign for elected office, and represent or be in business with a member of the legislature or administration overseen by the commission. The executive director of these ethics bodies should serve for a fixed term, removable only for cause. And whatever entity is in charge of ethics or campaign finance, reporting, and enforcement, it should be empowered to conduct random audits. Also, the definition of lobbying should be enhanced to include resolutions and advocacy done prior to a bill's introduction. It's one of the biggest loopholes right now is that lobbying under the state law is only defined on a bill that has been introduced formally into the legislature. We all know that a lot of effort goes into lobbying to try and even get to that stage of introduction. With regards to financial disclosure, we believe that strong disclosure is necessary and is a necessary complement to structural changes, as the public currently is largely in the dark concerning outside activities by lawmakers and potential conflicts of interest. In order to create more transparency and to prevent these conflicts of interest, Citizens Union supports the following. Outside income earned by legislators should be made public and income ranges tightened. Public officers and lobbyists should disclose their relationships with those doing business with the state, including clients of lawyers, with some exceptions. And a process should be established where lawyers could appeal to have particular clients remain unknown to the public. Financial disclosure forms should also be available online for elected officials. Pension forfeiture. Citizens Union recently took a position this spring on pension forfeiture and sees it as a sanction that should be available to a court when an elected official, head of state agency, or judge commits a specifically enumerated crime that is related to holding one's office. Specifically, we believe that imposition of the forfeiture penalty should be discretionary with the sentencing court, which must consider a list of specified factors. To those whose pensions are forfeited should be entitled to receive back their own contributions to the plan with interest. Medical and disability benefits should not be affected, and spouses and other beneficiaries who otherwise would be entitled to some or all of the pension should not lose those rights. Citizens Union supports forfeiture statutes that would apply to all elected officials, agency heads, and judges who are members of the pension plan, seeing no reason why currently employed public officers should be exempted from the forfeiture requirement should they commit one of the specifically enumerated crimes. Therefore, Citizens Union would support a constitutional amendment to remove the current limitation on officials who are currently members of the pension system. In the absence of a constitutional amendment, we would support a forfeiture statute which operates only prospectively, should have the other provisions as recommended above. With regards to campaign finance, a major component of the ethics legislation last year, which you all supported and helped champion and bring to a point where the governor chose to stand in the way of ethics reform and veto it, was the creation of a discrete campaign finance enforcement unit within the State Board of Elections. While Citizens Union does not currently believe that campaign finance reforms must be part of a new ethics legislation, provided that it is addressed in separate legislation, we support the following. That the Board of Elections should only be able to stop an investigation with a majority vote rather than start an investigation with a majority vote. The Board of Elections should have the power to initiate investigations and conduct random audits. Fines for violations of the campaign finance law should be higher. The Attorney General should be able to initiate investigations and prosecute cases involving public corruption, including serious election law malfeasance. Restrictions should be placed on the personal use of campaign contributions, and excess contributions should be disposed of after an established period of time has elapsed following the election. The Board of Elections should also better enforce the disclosure of independent expenditures, and legislation should require more explicit and targeted disclosure. disclosure form should link the candidate targeted and the type of expenditure for each expenditure reported. Thank you again for holding this very important hearing, and I'm now available to answer any of your questions.